So are we ready now? Should we begin? शुरू करना चाहेंगे कि इंतजार करेंगे थोड़ा और? क्या करेंगे? यस, अब आवाज आ गई. ओके. तो चलिए शुरू करते हैं. लेट अस बिगिन द प्रोसीडिंग. नहीं. uh, See, till this point, now today we are going to discuss this appearance and non-appearance of parties. And if one of the parties do not appear or both do not appear, what will be the consequence? So the topic says order 9 of CPC says and appearance of parties and consequence of non-appear. Appearance of parties and consequence of non-appearance. This is what is order 9. Appearance of parties and consequence of non-appearance. So if one party appear, another does not appear. If both do not appear, what should be done? There can be ex parte order, that is without presence of the parties. There can be ex parte decree, where the defendant is not present, I can pass decree against him. But there may be sufficient reason why a party does not appear, did not appear. So in that situation, that party should be given opportunity to bring this fact before the court, that why he was not able to appear before the court. Why he was not able to appear before the court. So in that sense, we are required to study this. We have read the procedure till this point. I have told you that first and foremost is that the plaint will be filed after the drafting of plaint as per order 2, order 1, order 4, order 5, order 6 and order 7. Order 6, 7, 4, 2 and 1. When the plaint is properly presented before the civil court as per section 9, and we reach to the jurisdiction, territorial jurisdiction of court as per section 16 to 20, then once the plaint is presented before the court, then the court will issue summons to the other party. Court will issue summons to the other party. So order 5 comes in picture, where summons are issued read with section 27 to 32 in that sense. And once the summons has been issued, the other party comes and he files his written statement as per order 8. And in written statement, he can claim set off or he can make a counter claim. So we read rules regarding this written statement and set off and counter claim also. So till this point, we have covered all this journey. Then we discussed another point that which is very important, that for determination of real controversy in issue, for determination of real question in controversy, we may be required to amend the pleading. So order 6 rule 17 is there, which can be invoked to amend the pleading, that is plaint for plaintiff and written statement for defendant. Both can be amended. So we read law regarding that amendment of pleading also as per Order 6, Rule 17, and we saw other amendments in APC like 152, 153, 153A, then Order 22, then Order 1, Rule 10, Sub Rule 2, various other provisions we read. Then we saw Order 6, Rule 16, that is compulsory amendment, and then Order 6, Rule 17, that is voluntary amendment. So now we are prepared. This amendment of pleading can be done at various stages you have read, so that is not exactly related to the stage, but this is necessary to be understood at the outset, and that is why I discussed that. Now we have moved to the next stage, that the parties are called for further proceeding. They are asked to appear before the court so that the court can examine them and court can proceed further for trial. So this is further process in trial. So if you read Order 9, Rule 1, it says on the day fixed in the summons for defendant to appear and answer, the parties shall be in attendance at the courthouse in person or by their respective pleaders, and the suit shall then be heard unless the hearing is adjourned to a future day fixed by the court. So it says on the day fixed in the summons for defendant to appear and answer. So this is the duty of court to issue summons for defendant to appear and answer. The parties shall be in attendance at the courthouse. The parties will obviously means plaintiff and defendant, in person or by their respective pleaders, and the suit shall then be heard. Suit shall then be heard unless the hearing is adjourned to a future day. Unless the hearing is adjourned to a future day fixed by the court. The court can fix the another day also. So what basically Order 9, Rule 1 says that it is mandatory for the party to appear before the court. So let us begin like this. Order 9, Rule 1. You can write down here. It is mandatory for the parties to appear before court. To appear before the court. To appear before the court on the day fixed for hearing of the suit. For hearing of the suit. The day is fixed in the summons and is called the date of first hearing. And that on this day both the parties must be present before the court either in person or by pleader. And only on their presence the suit will proceed further. The day is fixed in the summons. And the day is fixed in the summons and it is called first day of hearing. As we have started our proceeding now, first day of hearing. And on this date, both the parties should appear either in person or by their pleaders. Both the parties should appear either in person or by their pleaders. Is this clear? So now what happens next? Now, it may be that one of the parties appear, another does not appear. Maybe, no? It may be that the plaintiff appears, it may be that the defendant appears, it may be that the both do not appear. So there are various possibilities, probabilities. So if you see carefully, further proceeding will depend on the fact parties to appear. Now in this context, further Rule 2 says Dismissal of suit where summons not served in consequence of plaintiff's failure to pay cost. Where on the day so fixed it is found that the summons has not been served upon the defendant in consequence of failure of plaintiff to pay the court fee or the postal charge, if any, chargeable for such service, or failure to present copies of the plaint as required by Rule 9 of Order 7, the court may make an order that the suit be dismissed. So, Rule 2 basically deals with dismissal of suit. See, if you are prosecuting the suit, it is your duty as plaintiff to be vigilant, to be extra vigilant. And if you are not extra vigilant, court will punish you obviously for that. So that is what is dismissal of suit. So basically Rule 2 in a sense talks of plaintiff's duty. It talks of plaintiff's duty and its consequence on failure to perform duty. And its consequence on failure to perform duty. It talks of plaintiff's duty and consequence on failure to perform duty. So what are the plaintiff's duty? Plaintiffs की duty क्या है? The first is to pay court fees. This is plaintiff's duty, number one. Number two, to pay the postal charges. Number three, बुलाओ उसको, इधर क्लास रोक दो 1 मिनट के लिए, आवाज बहुत आ रही है. Just a minute, hold on. I'll take few minutes. क्लास को रोक दो 2 मिनट के लिए. तो कुछ ज्यादा ही आवाज आ रहा है, क्या किया है अभी? इतना तो आवाज पहले नहीं आता था. अरे सुन नहीं रहा है, क्लास स्टार्ट करो। तो ध्यान नहीं कहीं। तो plaintiff's duty is to pay court fees, to pay the postal charges, and now to present copies of plant. Present copies of plant. These are his duties. Present copies of plant. So to pay court fees, to pay postal charges, present copies of plant. Is this clear? Now this is the plaintiff's duty to pay. First I said court fee, second I said postal charges, and third I said copies of plant. So court fees, postal charges, and last I said copies of plant. So these are duty of plaintiff. This is CPC in a sense, or this is CCC, court charges copies. CPC, court fees, postal charges, copies of plant. Is this clear? To pay court fees, to pay the postal charges, present copies of plant. Is this clear? So rule 2 basically says, if you read rule 2 now, you know the plaintiff's duty, where on the day fixed it is found that the summons has not been served upon the defendant in consequence of the failure of plaintiff to pay the court fees. He did not pay the court fees or postal charges. This is his duty, if any, chargeable for such service, or failure to present copies of the plant as required by Rule 9 of Order 7. Now, you are required to present as many copies as defendant. The court may make an order that the suit be dismissed. If you default in performance of your duty, then obviously you will suffer. So this is what is Rule 2 saying, that the suit will be dismissed. Suit will be dismissed due to non-performance of plaintiff's duty. Because plaintiff is prosecuting the suit and he is not performing his duty. If I do not perform my duty, will you listen to me? The court will not listen to him. And it says, provided that no such order shall be made, if notwithstanding such failure, the defendant attends in person. Defendant comes to the court. Or by agent, when he is allowed to appear by agent on the day fixed for. So my main purpose was that he should come. He should come, and he has come. So proviso says that even if there is failure, there is failure on part of plaintiff, even if there is failure on part of plaintiff, even if there is failure on part of plaintiff, no, the defendant appears, the defendant appears the defendant appears appears either in person or by his agent. Now, then the suit will not be dismissed. Then the suit will not be dismissed. Because my main purpose is to call the defendant. So defendant has come. Is this clear? Nothing great? So in this situation, the suit will not be dismissed. Now what Rule 3 says? Where neither party appears, suit to be dismissed. Where neither party appears when the suit is called on for hearing, court may make an order that the suit be dismissed. Court may make an order. So it is discretion of court. Rule 3, neither party appears, means nobody is serious. The court may dismiss suit. It doesn't say that the court shall dismiss the suit, may dismiss. So court will exercise its discretion, may or may not dismiss the suit. Now what the plaintiff will do then? Plaintiff may bring fresh suit or court may restore suit to file. So you can bring the fresh suit, but if you bring the fresh suit, you will have to file the fresh court fees. And if you talk of restoration of suit which has been dismissed, then you will save your court fees. So what is the better recourse? Of course, restoration of suit. Where suit is dismissed under Rule 2 or Rule 3, plaintiff may, subject to the law of limitation, bring a fresh suit, or he may apply for an order to set the dismissal aside. And if he satisfies the court that there was sufficient cause for such failure as is referred to in Rule 2, or for his non-appearance as the case may be, the court shall make an order setting aside the dismissal and shall appoint a day for proceeding with the suit. So there can be restoration. And you must understand, I said that in Rule 4, plaintiff has two courts. Plaintiff has two alternatives. One can bring fresh suit, and the second can pray for dismissal of order or setting aside, can pray for setting aside dismissal order. Setting aside dismissal order, it means he may pray for restoration of suit. He may pray for restoration of suit. So can bring fresh suit or can pray for restoration of suit? Which is the better recourse? Can bring fresh suit or can pray for restoration of suit? Is this clear? Now, in such a situation, what will happen? If you want to bring a fresh suit, limitation will come in picture and you will have to pay the court fees also. Bringing fresh suit will attract court fee and limitation as well. Whereas a restoration of suit will not attract this. So which is the better course? Obviously this is the better course. So you always pray for restoration of suit rather than bringing a fresh suit. This is better. This is better, all right. So Rule 4, this rule provides for remedy available to the plaintiff in case suit is dismissed under Rule 3 or 4, Rule 2 or 3. Plaintiff may bring a fresh suit on the same cause of action or may apply to court to set aside the order of dismissal by providing sufficient cause for his absence, or for committing that fault. To bring a fresh suit, law of limitation will apply. The dismissal under Rule 2 or Rule 3 is known as dismissal on default, because this is not dismissal on merits, and res judicata will not apply. So question is, can res judicata apply? Does res judicata apply? The answer is no, because it is not on merits. This is dismissal on default. Does res judicata apply? The answer is no. Answer is because it is dismissal on default and not on merits. This is dismissal on default, not on merits. It is dismissal on default, not on merits. Is this clear? I think there is no problem at all. This is very simple things. So this is dismissal on default, not on merits. Now, when you move further, and you take further point. Rule 5, summons returned unserved. Dismissal of suit where plaintiff, now I am reading the Bar Act only. Dismissal of suit where plaintiff after summons returned unserved fails for 7 days to apply for fresh summons. Whereafter summons has been issued to defendant or to one of several defendants and returned unserved, the plaintiff fails for a period of 7 days from the date. So this is also duty of plaintiff in a sense that Rule 5 says that if someone has returned unserved, you make an effort to serve summons again. What is the problem? Rule 5 says, where after a summons has been issued to the defendant and returned unserved, summons served to defendant and returned unserved, now, so when it returns unserved, it is plaintiff's duty. It is plaintiff's duty to apply for fresh service. Within 7 days. Read the Bar Act. It also deals with plaintiff's now duty. So it says in Rule 5, whereafter summons has been issued to the defendant or to one of several defendants and returned unserved, it could not be served. The plaintiff fails for a period of 7 days from the date of return made to the court by the officer ordinarily certifying to the court returns made by the serving officer to apply for issue of fresh summons. So, if it returns unserved, which has been certified by the person serving the summons, he comes to the court and he certifies that it has not been served. So, in that case, it is the duty of plaintiff to make an application within 7 days. Now, to apply for the issue of fresh summons, the court shall make an order that the suit be dismissed as against such defendant unless the plaintiff has within the said period satisfied the court that he has failed using his best endeavor to discover the residence of defendant who has not been served. So he will give the reason. And I made my best effort, but it could not have been served. Or such defendant is avoiding service of process. There is another sufficient cause for extending the time, in which case the court may extend the time for making such application for such period as it thinks fit. In such case, the plaintiff may bring a fresh suit, subject to law of limitation. So it says, where after a summons has been issued to the defendant or to one of several and returned unserved, plaintiff fails for a period of 7 days from the date of return. from the date of return. Fresh service within 7 days from the date of return. So if it has been returned today, so within 7 days you apply for fresh summons. Apply for fresh service. No, plaintiff fails to apply for issue of fresh. The court shall make. So if this is plaintiff duty, but if fails, but if he fails, if he does not do, then what will be done? Then it says court shall make an order that the suit be dismissed. Then court may dismiss suit. Because it is plaintiff's fault. Court may dismiss suit. Is this clear? As against such defendant. Unless, but there is an exception, that it may not be done so. So exception is there in Rule 5, which says but suit may not be dismissed suit may not be dismissed if suit may not be dismissed if suit may not be dismissed if what? If plaintiff satisfies plaintiff satisfies plaintiff satisfies plaintiff satisfies that for sufficient reason he could not come to the court. So obviously now you will have some relaxation, relief for him. But obvious law is nothing but common sense. This is common sense, absolute common sense. So that is what it says. The plaintiff has within the said period satisfied. The plaintiff satisfies that he failed even after his best endeavor, even after his best effort, even after his best effort. Number 2, such defendant is avoiding service. So write down only that the defendant avoided service. Defendant avoided service, what can I do? It is not my fault. Why should I be punished? Defendant was avoiding all time the service. And I made the best effort. Will you penalize me? And for defendant's fault, will you penalize me? The answer is no. Number 3, there is any other sufficient cause. Any other sufficient cause. Any other sufficient cause. I could not come to the court. I could not come to the court earlier because I was on the deathbed or I was seriously ill. Any other sufficient. For extending the time in which the court may extend the time for making such application for such period as it thinks fit. The court can extend the time. Suit may not be dismissed if the plaintiff satisfies that he failed even after his best effort, defendant avoided service, or any other sufficient cause. So in that case, court will extend the time. Court will extend time. Court will, in such case, the plaintiff may bring a fresh suit. And if it is dismissed, then the plaintiff may bring again a fresh suit. Plaintiff may bring a fresh suit. In such case, the plaintiff may, subject to the law of limitation, bring a fresh suit. Is this clear? If the suit is dismissed, plaintiff may bring a fresh suit. Procedure where only plaintiff appears, defendant does not appear. Only plaintiff appears, defendant does not appear. Rule 6. Only plaintiff comes. Defendant does not come. So what will you do? This is where the plaintiff appears and the defendant does not appear when the suit is called on for hearing. Then when summons has been duly served, court may make an order that the suit be heard ex parte. When summons not duly served, if it is not proved that the summons was duly served, the court shall direct a second summons. Summons not duly served, second summons. When summons served but not in due time, it has been served and it has been served yesterday, and it has been very difficult for me to reach to the court today. In many cases it happens. Now, in many cases you will receive the summons now just 1 day before. This is not when summons served but not in due time. Summons served but not in due time. So only plaintiff comes, defendant does not come. Only plaintiff comes, defendant does not come. And suit is called for hearing. Suit is called for hearing. क्या करेंगे आप? Plaintiff has come, defendant does not come. Summons was duly served, then it should be heard ex parte. When the summons has been served on defendant, it does not come, so it is whose fault? Defendant's fault. So it should be heard ex parte. No? When summons not duly served, there may be now requirement of again service, so we have written second service. And when summons served but not in due time, so they will give the time. So there are various situations. When summons duly served, सर्विस कर दिया फिर भी वो नहीं आया. Summons duly served. So now the common sense, a defendant has been duly told that there is a case against you and he does not come. So it should be heard. Case should be heard ex parte. Case should be heard ex parte. Is this clear? Case should be heard ex parte. B. When summons not duly served. When summons not duly served. Not duly. Summons duly served, heard ex parte. Summons de diya defendant ko and defendant does not come. It is whose fault? Defendant's fault. So I will hear ex parte. That is, without defendant, I will hear the case. When summons not duly served, then what should be done? You think common sensically, you will say that yes, then we'll issue another summons. 2 second summons. This is quite commonsensical. Second summons. Issue second summons. And summons not duly served, issue second summons. Number 3, when summons served but not in due time. Summons served but not in due time. So you give time. This is common sense. So you give more time. So what it says, if it is proved that the summons was served on the defendant but not in sufficient time, when summons has been served in such a way that defendant does not get sufficient time, defendant does not get sufficient time to appear and answer on the day fixed, does not get sufficient time to appear and answer. To appear and answer, does not get sufficient time to appear and answer, then the court shall postpone the hearing. Postpone hearing, this is the crux on for suitability, na? On a future day to be fixed by the court and shall give direct notice of such day to be given to the defendant. Postpone hearing to future day and will give notice to defendant. Notice to defendant. Postpone hearing and notice to defendant. Summons served but not in due time. So we'll give time, no issue, and we'll give notice to the defendant to appear. This is commonsensical. Is this clear? The rule 6 does not contain much. Now see rule 7. Now then sub rule 2 is also there. So rule 6 sub rule 2. Where it is owing to the plaintiff's default that the summon was not duly served or was not served in sufficient, the court shall order the plaintiff to pay the cost occasioned by the postponement. So subsection 2 says if plaintiff is under default, then the court will ask him to, when plaintiff is under default, then the court will ask him to pay the cost occasioned by postponement. Pay the cost occasioned by postponement. Pay the cost. Stop here. Pay the cost. I think these are all commonsensical points. There is nothing great in it. Now, rule 7, procedure where defendant appears on the day of adjournment hearing and assign good cause for previous non-appearance. Order 9, rule 7. Now, where the court has adjourned the hearing of the suit ex parte and the defendant at or before such hearing appears and assigns good cause for his previous non-appearance. Why I could not appear? He says now he may, upon such terms as the court directs as to the cost or otherwise, be heard in answer to the suit as if he had appeared on the day fixed for his appearance. So now procedure where defendant appears. If defendant appears on the day adjourned or fixed for adjourned hearing, and later on hearing, adjourned hearing, on the day fixed for adjourned hearing, or before, the defendant appears on the day or before, both, or before that day, and assigns good reason. And assigns good reason for his previous non-appearance. For his previous non-appearance. Then he may be heard. Then he may be heard in answer to the suit as if he had appeared. May be heard as if he had appeared earlier. So no. So his earlier fault is now washed away. He may be heard as if he had appeared earlier, because he has given good reason, assigns good reason for his previous non-appearance. So we'll excuse him for that reason. Is this clear? Now rule 8 says procedure where defendant only appears. Where defendant only appears. Various possibilities, probabilities. Defendant only appears. Obviously, plaintiff will suffer. Where the defendant appears and the plaintiff does not appear when the suit is called on for hearing, the court shall make an order that the suit be dismissed, because plaintiff is not serious, so suit be dismissed, unless the defendant admits. But if he admits the claim or part thereof, in which case the court shall pass a decree against the defendant upon such admission, and where part only has been tendered, shall dismiss the suit so far as it relates to the remainder. All right. So it says, now, then the court first shall dismiss the suit. Court shall dismiss the suit. Number one. Shall dismiss the suit. If defendant admits claim, then decision on that admission, because admission can be reason for decision. If you admit my claim, there is no problem with the court. Order 12 rule 6 also says that there can be decision on the basis of admission. If I make a claim against you of rupees 500 and you admit 300 rupees claim, so my judgment of 300 rupees can be awarded easily, because there is no dispute regarding 300 rupees. There is only dispute regarding 200 rupees, so that will be decided later on. So if defendant admits claim, then decision on that admission. All right. Number 3, where part only has been admitted, shall dismiss the suit so far as it relates to the remainder. If defendant admits Part claim, defendant admits part claim, where part only of the claim has been admitted. Then the court shall dismiss the suit so far as it relates to the remainder. Admits part claim, then court will dismiss the rest of the claim. First dismiss the suit, entire suit, because plaintiff is not there. Defendant admits claim, this is his benevolence, then will decide accordingly. Or if he admits part of the claim and he does not admit part of the claim, so we will decide on the basis of part admitted and will reject the suit regarding the part not admitted. Very, very simple. Order 9, Rule 8. Order 9, Rule 9. Decree against plaintiff by default bars phrase suit. Where a suit is wholly or partly dismissed under Rule 8, the plaintiff shall be precluded from bringing fresh suit in respect of the same cause of action. Precluded means excluded. He cannot. But he may apply for an order to set the dismissal aside. So he can do this. And if satisfies the court that there was sufficient cause for his non-appearance, then the suit shall be called for hearing. The court shall make an order setting aside the dismissal upon such terms as to the cost or otherwise as it thinks fit, and shall appoint a day for proceeding with the suit. So decree against plaintiff by default bars fresh suit. So Rule 9 says, if a suit is wholly or partly where a suit is wholly or partly dismissed, a class is pausing again and again. If a suit is wholly or partly dismissed, Order 9, Rule 9, then the plaintiff shall be precluded from bringing a fresh suit in respect of that cause of action. If a suit is wholly or partly dismissed, then in that case, plaintiff cannot bring a fresh suit in respect of that cause of action. But he may apply for an order to set the dismissal aside. Then plaintiff can't bring fresh suit, but he can ask for setting aside dismissal. But he can ask for setting aside of dismissal. And if court is satisfied, that there was sufficient reason for non-appearance. There was sufficient reason for non-appearance. There was sufficient reason for non-appearance. If court is satisfied that there was sufficient reason for non-appearance, then sufficient reason for non-appearance, then the court shall make an order setting aside the dismissal. Then the court shall order setting aside of dismissal. Then the court shall order setting aside of dismissal. Is this clear? Let us take a little bit break, then we'll begin. Order 9, Rule 9 is covered. Order 9, Rule 9 is covered, my dear friend. Please look into the matter. Very simple. Order 9, Rule 9. So Rule 9 is over. Is this clear? Decree against plaintiff by defendant default bars fresh suit. All right. Rule 10, procedure in case of non-attendance of one or more of several plaintiffs. So it says procedure in case of non-attendance of one or more of several plaintiffs. Where there are more plaintiffs than one, and one or more of them appear, and others do not appear, the court may, at the instance of plaintiff or plaintiffs appearing, permit the suit to proceed in the same way as if all the plaintiffs had appeared, or make such order as it thinks fit. Where there are more plaintiffs and one or more appear, and others do not. One or more appear and others do not. Where there are more plaintiffs, one or more appear and others do not. Then what will happen? The court may, at the instance of the plaintiff or plaintiffs appearing, permit the suit to proceed in the same way as if all the plaintiffs had appeared. Then the court may, at the instance of plaintiff or plaintiffs appearing, may, at the instance of plaintiff or plaintiffs appearing, permit the suit to proceed. Permit the suit to proceed as if all the plaintiffs had appeared. As if all the plaintiffs have appeared. It will be considered that they have appeared. No harm, there are some plaintiffs there, so one or more appear, it will be believed that uh, all the plaintiffs have appeared. Non-attendance of one or more. No, otherwise, the suit will be languishing. One has appeared and one has not appeared. Suit will be languishing. Is this clear? Is this clear? Then oh, I think all people are concerned about their exams and they do not want to come to the class. No, this happens. Just see Rule 11, procedure in case of non-attendance of one or more of several defendants. I could not understand why people are not here. I don't know. Not able to know exactly what has happened. So, Rule 11, procedure in case of non-attendance of one or more of several defendants. Non-attendance of so one does not come or others do not come. Non-attendance of one or more several defendants. So now, if this is the region, then now Rule 11 says where there are more defendants than one or more of them appear and others do not. Some have appeared, some do not. And the court shall at the time of pronouncing judgment make such order as it thinks fit with respect to defendants who do not appear. Court shall at the time of pronouncing judgment to make such order as think fit with respect to defendants who do not appear. So now the court has got the liberty, the court has liberty to pronounce judgment the court has liberty to pronounce judgment and make such order with respect to defendant the court has liberty to pronounce judgment and make such order with respect to defendant who do not appear. Court has liberty to pronounce judgment and make such order. Court will think now what to do, what not to do. So there is nothing great in this. You see carefully, kuch aaye, kuch nahi aaye. So now, generally in such situation, court will believe that all have come. Is this clear? Court will believe that all have come. Court will believe that all have come. They can order to appear in person. Where a plaintiff or dependent who has been ordered to appear in person does not appear in person. Now, Rule 12 talks of different situation where we have ordered you to appear and you do not appear. Then what should be done? So it says consequence of non-attendance without sufficient cause shown of party ordered to appear in person. Where a plaintiff or defendant has been ordered, and a court has asked them to come to appear in person, does not appear. Or show sufficient cause. Or show sufficient cause for failure to appear. So sufficient cause to failure to appear. Sufficient cause for failure to appear. He shall be subject to all the provisions of foregoing rules applicable to plaintiffs and defendants respectively who do not appear. So in such a situation, it will be deemed, does not appear in person, this is one, has been ordered to appear, does not appear, or show sufficient cause to the satisfaction of court for failing to appear. He shall be subject to all provisions of applicable to the plaintiffs respectively who do not appear. So it will be considered. No, you write like this. So in such situation, he will be deemed to be absent and will be subject to similar restriction, limitation or restriction. Similar limitation or restriction. Where a plaintiff or defendant has been ordered to appear in person, does not appear in person, or so sufficient cause for failure to appear. So, in such a situation, he will be deemed to be absent and will be subject to similar limitation or restriction. Similar limitation or restriction. Similar limitation or restriction. The above mentioned provisions shall apply mutatis mutandis. It will be deemed that the party did not appear. It will be deemed that the party did not appear. ऐसा मान लिया जाएगा. It will be deemed. Now see the rule 13, which is very, very important. It says, in any case in which decree is passed ex parte against the defendant, he may apply to the court by which the decree was passed for an order to set it aside. And if he satisfies that the court, the summons was not duly served, or that he was prevented by any sufficient cause from appearing when the suit was called on for hearing, the court shall make an order setting aside the decree as against him upon such terms as to the cost, payment into the court or otherwise as it thinks fit, and shall appoint a day for proceeding with the suit. So now it is the right of defendant to ask the court to set aside ex parte decree, and defendant can show the sufficient reason for that. Now he can, so you write down, the rule 13 is very, very important. You can have a question on this, rule 13. Rule 12 was not important, rule 11 is not important, that is not so important, but rule 13 is very, very important. So you write down, where a decree is passed, against defendant ex parte, where a decree is passed against ex parte, where a decree is passed against defendant ex parte, then the defendant can apply to the court when a decree is passed against defendant ex parte, when a decree is passed ex parte against defendant, then when a decree is passed ex parte against defendant, then the defendant can apply to the court, then the defendant can apply to the court passing the decree, then the defendant can apply to the court passing the decree, then the defendant can apply to the court passing the decree to set it aside. Then the defendant can apply to the court passing the decree, then the defendant can apply to the court passing the decree to set it aside. Set it aside. And the court can be approached on the ground and the court can be approached on the ground that the number one, summons were not duly served. The summons were not duly served. Summons were not duly served. Number one. Summons were not duly served. Number two, there was sufficient cause which prevented him to appear. There was sufficient cause there was sufficient cause which prevented him to appear. Which prevented him to appear. Then next, this application must be made within 30 days. This application must be made within 30 days. This application must be made within 30 days. This application must be made within 30 days from the date of decree. This application must be made within 30 days from the date of decree. This application must be made within 30 days. This application must be made within 30 days from the date of decree. And where summons were not duly served, and where summons were not duly served, आपको पता ही नहीं था, where summons were not duly served, where summons were not duly served, where summons were not duly served, from the date when he has knowledge of the decree, when he has knowledge of the decree. तो जब से उसको जानकारी मिली तब से 30 दिन का समय, when he has knowledge of the decree, when he has knowledge of the decree. Then there is question, can irregularity in service of summons be a good ground for setting aside ex parte decree? This is the second proviso. Can irregularity in the service of summons be good ground for setting aside ex parte decree? That is the question. So on this point, law says irregularity in the service of summons irregularity in the service of summons irregularity irregularity in service of summons is not a ground, for setting aside ex parte decree. Is not a ground for setting aside ex parte decree. Is not a ground for setting aside ex parte decree. Is not a ground for setting aside ex parte decree. But this will apply when the defendant had notice and had sufficient time. So he cannot bring irregularity to set aside the ex parte decree. No, no. He had a notice and he had sufficient time also. So he should have appeared. Irregularity in the service of summons is not the ground. You cannot take benefit of irregularity. No, no, no. So here the condition is that the defendant had notice and sufficient time to appear. And sufficient time to appear before the court. Sufficient time to appear before the court. Sufficient time to appear before the court. So you should appear. What is the problem then? Now then write down further. In granting the relief against ex parte decree, the court can exercise discretion based on sound judicial principle. Court can exercise discretion based on sound judicial principle. And the court will grant the relief of setting aside ex parte decree. Court will grant the relief of setting aside ex parte decree in case of non-service of summons, or in case of summons not duly served, or due to sufficient cause, Now, what can be sufficient cause or due to sufficient cause? Now, sufficient cause can be, you can write down the list of sufficient cause. sufficient cause. Number one, improper advice of advocate. Bona fide mistake of defendant. Fraud of the other party. Negligence of guardian or next friend. Negligence of guardian or next friend. So this can be sufficient cause. Then number five, death of near relative. Imprisonment. Somebody is act of God. Now act of God is like now what happened in Tirupati. Flash flood or something like that, landslide. You can't do anything. Lockdown. If my area is completely locked down, how can I appear in another state or in another district? We cannot. Act of God, vis major. That is called vis major. Vis major. Act of God. Vis major. So that is unfortunate, unforeseen incidents. Now, like I said, flash flood or some kind of flood, whereby you are prevented to go to the court. So what can you do? You can't do anything. You are helpless. You're helpless. What is not sufficient cause? Not sufficient cause. This is clear? Not sufficient cause. So on this point you can write down dilatory tactics. So you are again and again seeking time and adjournment, unnecessary. You do not want to come. That is bahanebaji, you are pretending. Counsel busy in other court. So we'll not wait for indefinite time. We cannot wait. So we'll decide the case. Suits of high valuation or suit of high valuation. That is why you are avoiding this. You are not coming to the court. Not absence of defendant after prayer of adjournment. Absence of defendant after prayer of adjournment. Now we gave adjournment and even then you are absent. We gave adjournment, so I allowed you to appear on another day, adjournment. We postponed the case, and even then you do not come. So, is it a good reason to listen to you later on? The answer is no. It means you are ill serious. If the suit is of high valuation, you are not appearing. Counsel is busy in another court, so who will come to this court? These are not the valid reasons. Mere thinking that the case will not be called. Now, you may believe that there is a long list, so my case is listed at number 40, so it will not come. Mere thinking that the case will not be called. Mere thinking that the case will not be called. Now, what is the remedy in such situation? Now, when there is ex parte decision, what is the remedy available to you? What is the remedy available to you? What should be done? The remedy when there is ex parte decree, what will you do? Remedy against ex parte decree. Now you are aggrieved that the ex parte decree has been passed against me. So what you can do in law? What are the remedies available? What are the remedies available? So you can look into this case also written in your material. I hope Bhanu Kumar Jain versus Archana Kumar 2005 1 SCC. Can you see this? Written in your Bear Act, Ambition Bear Act. Bhanu Kumar Jain versus Archana Kumar. Bhanu Kumar Jain versus Archana Kumar. It was observed that the defendant has three remedies. Oh, just right done. Bhanu Kumar Jain versus Archana Kumar. 2005 1 SCC, page 787. The court said that the defendant has three remedies. That the defendant has three remedies. Court said that the defendant has three remedies against a decree passed ex parte. Defendant has three remedies. Number one, first remedy is appeal. Even ex parte decree is appealable, appeal under section 96 subsection 2, it is written there. Review under order 47 rule 1. So second is review under order 47 rule 1. So you can go for review. And third, setting aside ex parte decree. So you can approach the same court, setting aside ex parte decree. Order 9 rule 13. Order 9 rule 13. These are all preliminary question also. What are different remedies available to a person against whom ex parte decree has been passed? So it says he can go in appeal in section 96 subsection 2, there is provision. And he can go for review, order 47 rule 1, or he can get this order set aside, decree set aside, order 9 rule 13, setting aside ex parte decree, order 9 rule 13. Order 9 rule 13. Order 9 rule 13. Order 9 rule 13. Appeal under 96 subsection 2, review under order 47 rule 1, setting aside ex parte decree, order 9 rule 13. Remedy against ex parte decree. Is this clear? This is aggrieved party, that is generally defendant we are talking about. See, there is another case in your Bear Act, N. Mohan versus R. Madhu, civil appeal number 8898 2019 decision. This was not reported. Supreme Court has now observed that a defendant cannot be deprived of his statutory right to appeal under section 96 subsection 2 of CPC merely on the ground Earlier, the application filed under Order 9 Rule 13 was dismissed. So even if an application under Order 9 Rule 13 is dismissed, you can go in appeal, no problem. So you can write down, even if application under Order 9 Rule 13 is dismissed. Even if application under Order 9 Rule 13 is dismissed, Order 9 Rule 13 is dismissed, defendant can go in appeal. Defendant can go in appeal. Even if application under Order 9 Rule 13 is dismissed, defendant can go in appeal. Defendant can go in appeal. Application under Order 9 Rule 13 is dismissed, defendant can go in appeal. No problem. Then it says further, even if application under Order 9 Rule 13 is dismissed, defendant can go in appeal. There is no issue. Suppose a person has filed appeal first against ex parte decree and appeal is dismissed. Then can he go under Order 9 Rule 13? Here the law says no. But if defendant goes in appeal first, which is dismissed, then he cannot seek relief under Order 9 Rule 13. Because you have gone to higher court and your appeal is dismissed. So higher court does not find merit in your matter. So can you visit the lower court for setting aside the ex parte decree? That is what is being said. No. So you take care, you be prudent. Now, this is for in any case the decree is passed ex parte against defendant, he may apply. So Order 9 Rule 13 is available to defendant. Order 9 Rule 13 is available to defendant. Clear? Setting aside ex parte decree, he can go. Obviously, he is the aggrieved party. Now, suppose you set aside the ex parte decree. You set aside ex parte decree. Under Order 9 Rule 13, defendant is happy, but plaintiff is now unhappy. What should he do? What should he do? Suppose, you can write like this, if court set aside ex parte decree, court set aside ex parte decree, but the plaintiff feels aggrieved. He is aggrieved now. He thinks that the decision is wrong. Now, where will he go? What he will do? So, on this point, now law says that he can go for revision because he can raise question of exceeding of jurisdiction or non-exercise of jurisdiction or not proper exercise of jurisdiction. So, he can go for revision. In absence of any provision, you cannot answer any other thing. So, he can go for revision. He can always raise a question that the court has exercised its jurisdiction improperly, or it exceeded jurisdiction, or it did not exercise jurisdiction properly. So, that can be ground for plaintiff. That can be a ground for plaintiff. Is this clear? That can be ground for plaintiff. That can be ground for plaintiff. All right, my dear friend. That can be ground for plaintiff. What is the effect of setting aside ex parte decree? Now, when I do not quote the name of the case, you should not worry about the name of the case. Now, overloading of anything is not good. नहीं, ये सब reported judgment नहीं है ना, ये reported judgment नहीं है. N Mohan versus R Madhu लिखा तो है बैरक में. अननेसेसरी चीजों में ज्यादा परेशान नहीं होना है हमने. मैं इसीलिए कुछ चीजें आपको बताता हूँ, कुछ नहीं बताता हूँ, so that I should balance. Now, you listen to the important question. What is the effect of setting aside ex parte decree? What is the effect of setting aside ex parte decree? It leads to restoration of suit and trial commences de novo. Effect of setting aside ex parte decree. So you can write, it leads to restoration of suit. It leads to restoration of suit and trial commences de novo. Trial commences de novo. What about plaintiff's evidence after setting aside ex parte decree? Now, plaintiff has already given evidence. What will happen to that? So, what about he has? What about plaintiff's evidence which he has already deposed or brought? Which he has already deposed or brought before the court. So, on this point, so you write down this point. You write down this point, what I said. The evidence will be brought to the court. The evidence will be brought to the court again. So what I said, evidence will again be given to the court as it will be considered a de novo trial. Court will again hear the pleadings, evidences and material fact. Is this all right? Is this all right? So write down, my dear friend. So write down. It will be considered sorry. It will be considered a case of de novo trial. So trial will go afresh. De novo means afresh, trial afresh. So again you will have to bring evidence. Everything will begin afresh. Court will again hear the pleadings, evidence and material fact. Court will again hear the pleadings, the evidence, and material facts. Court will again hear the pleadings, evidence, and material facts. Now, in clarifying the law in G. Ratnaraj, clarifying the law in G. Ratnaraj versus Sri Muthu Swami Permanent Fund Limited. G. Ratnaraj, G. Ratnaraj, G. Ratnaraj. This is Order 9, Rule 13. G. Ratnaraj versus Sri Muthu Kumar Swami Permanent Fund Limited. Sri Muthu Kumar Swami Permanent Fund Limited. This is, I do not have citation. The judgment date is February 2019. Judgment date is February 2019. February 2019. So what happened in this case? I tell you, the court said, this is February 1, 2019 judgment of Supreme Court. Supreme Court judgment. What the court said. Now the Supreme Court said, that decree passed after plaintiff's evidence without defendant's appearance. Just see, the decree passed after without defendant's appearance at trial is ex parte. Is ex parte. Is ex parte decree. This will be considered ex parte decree because defendant's appearance is not there. The defendant's appearance is not there, so even if plaintiff has given the evidence, it's zero. It will be considered ex parte. Correctly so, it will be considered ex parte. It will be considered ex parte. Even though defendant has submitted, WS. So submission of WS is not a big issue. Is this clear? Even if now WS is filed, that doesn't matter at all. Are you getting the point? I have written this in your Order 17 Rule 2, if you can see this. Order 17 Rule 2, G. Ratna Raj versus Sri Muthu Kumar Swamy Permanent Fund Limited 2019 judgment. Rule that decree was not passed invoking explanation 2 of Rule 2 of Order 17. Can you see Order 17 Rule 2, what it says? Let us see once. Where on any date to which the hearing of the suit is adjourned, the parties or any of them fail to appear, the court may proceed to dispose of the suit in one of the modes directed in that behalf by Order 9 or make such order as it thinks fit. So, if the party does not appear or fail to appear, then the court will proceed as if the party is not there and the Order 9 will apply. Now, explanation says, where the evidence or a substantial portion of evidence of any party has already been recorded and such party fails to appear on any day to which hearing of the suit is adjourned, the court may in its discretion proceed with the case as if such party were present. So, question is that Order 17 Rule 2 explanation will apply in the case of defendant here. The answer is no, because defendant has not appeared. He does not give any evidence as such. He does not give any evidence as such. So, G. Ratna Raj says, the decree was not passed invoking explanation 2 of Rule 2 of Order 17. That situation will arise only if the party is absent and the party has given evidence. If the party has given evidence and then he is absent, then Order 17 Rule 2 explanation will come in picture. But this is not the case with this person, this defendant who has not given evidence at all. And submission of WS is not giving of evidence. You know, pleading, you do not give evidence. You plead facts, material facts, no evidence. No evidence. In plant and WS, no evidence. So, just submission of WS by defendant is not production of evidence, mind you. So, even if he has produced WS, it does not mean that he has given evidence. No, he will not be considered. It is ex parte. Supreme Court has said very clearly in G. Ratna Raj that plaintiff's evidence has been given, but defendant's evidence has not been given. And we are passing ex parte decree against defendant. So, Order 17 Rule 2 explanation is not attracted in this case, which says that it will be attracted in the case where the party has already given evidence and then he is absent. But has the party given evidence here in case of this defendant? No. So, if he has not given evidence, Order 17 Rule 2 explanation doesn't apply. So, you can write down from my side, that's very clear, that in this case Order 17 Rule 2 explanation is not attracted. You write in G. Ratna Raj. In this case Order 17 Rule 2 explanation is not attracted. Supreme Court said that in this case Order 17 Rule 2 explanation is not attracted because that will apply only in the case because that will apply only in the case because that will apply only in the case sorry, where the person has or the party has given evidence, where the party has given evidence either wholly or substantially, either wholly or substantially, and then he fails to appear. 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 In other words, the substantial evidence of absentee party is available. In other words, substantial evidence of absentee party is available. So he is considered to be present. So he is considered to be present. So he is considered to be present. This is how you have come to the end of order 9. Appearance and non-appearance of the party. Just read the bare provision carefully. Try to apply your mind. Order 9, Rule 13 is important. Material is written in your bare act also. I have also given you dictation on the point. No decree to be set aside without notice to opposite party. So whenever you want to set aside the ex parte decree, notice to opposite party is necessary. Order 10 doesn't have much, order 11 doesn't have much. But these are relevant for preliminary, maybe asked a question here and there, so you have to be careful. We'll be reading this. No? Order 11 and this discovery and inspection. Discovery, disclosure, discovery and inspection of documents ensued before commercial division of the High Court or commercial court. That is also there. So you can just have a glance, nothing great. Order 12 is admission, sometimes preliminary questions. Preliminary question. Preliminary question. पढ़ेंगे इन सबों को भी, लेकिन इस सच्चाई से बोलूं तो आपकी क्लास में ना मज़ा नहीं आ रहा है, क्योंकि बच्चे बहुत कम आ रहे हैं. पता नहीं क्या करें हम इनका, मुझे समझ नहीं आ रहा. आई कांट हेल्प इट. क्वेश्चन भी आया है सृष्टि गुप्ता का. सृष्टि जी, क्वेश्चन का समय तय है हम लोगों का कि पढ़ाने के बाद पूछना है. आपने बीच में ही पूछा है, बट क्वेश्चन आपका अच्छा है. आपने पूछा है डेली शेड्यूल का, टाइम मैनेजमेंट का. तो देखिए, एक समय सीमा तो बनानी पड़ेगी, एक शेड्यूल तो बनाना पड़ेगा. आप क्लास में जो पढ़ते हैं सबसे पहले तो उसको रिवाइज करिए. You make it a habit. Everybody should make it a habit that whatever you read today, you should not be in great hurry. You should not be running in hurry. No, just justice hurried is justice buried. So first you understand now, like you are reading CPC. In CPC, you will take 2.5 months at least in understanding CPC. It's a huge subject. And you have to go a little bit now. Now, see, order 11 onwards till order 19, you do not have much. So you can run through. But now, till this, now in order 7, order 6, order 2, order 1, order 5, even order 8, order 9 also, you are required to uh, devote time. See, this order 1 to 20 is basically the trial process. So almost you are done with the 70%, 80% you can say. Now the rest of the things are very easy, very, very easy. So difficult part of CPC is gone, and nothing is difficult if you work really hard and if you read carefully. Like this different provisions. Now now just related this order 9 rule 13 with the order 17 rule 2 explanation. So this kind of understanding is required. This kind of understanding is required. So as far as now daily schedule का आप कह रहे हैं तो आप पहले तो class के साथ चलना सीखो. Solve the question, whether you are able to solve it or not, but try to solve it. Read it, make it a habit. I have to solve question. At least now, the questions which are there in your material, subjective question, objective question, you solve them. You solve them. Is this clear? And rest, you go along with the coaching classes. If you are attending the classes, don't be in hurry. CPC is such a subject where you should concentrate only right now on CPC. Even suppose that you are a fresher and you are going to appear in Rajasthan, you just go and appear, have a feel. Don't expect too much because you are not prepared. So even if you solve 10%, 20%, 30%, you should be happy about that. Unnecessary, don't overburden yourself. After preparing for 1 year, I am saying, then you will feel little comfort. If you are extra intelligent, it may happen in 3 months, it may happen in 1 month, it may happen in 6 months. But generally, I am saying, that now you are required to concentrate on what is there. So if class is going great, I will continue with the class. I have no issue. I have only one issue, that I can see very less presence of the people in the class, which I do not feel good about. Bharti, Order 9, Rule 13 and Order 17 means ex parte decree can be issued against, again, plaintiff dependent on any hearing if evidence is not produced. नहीं, आप ये Order 9 Rule 13 तो ex parte decree की बात करता है. हमने कहा ex parte decree में presence और absence की बात है. Question is, if the party has not given evidence, is he considered present? So I said Order 9 Rule 13 says he is considered not present. So in that regard, Order 17 Rule 2 explanation says that if he has given substantial evidence or whole evidence and then he is not present, देखो कितना logical, it's common sense. If somebody has given already evidence or substantial evidence, will you consider him absent or present? Even if he is not present later on. So I will consider him present because he has already given his evidence. So Order 17 Rule 2 explanation says if he has given whole evidence or substantial evidence, he is considered present. It is not ex parte in that sense. So Order 17 Rule 2 explanation says it is not ex parte. Whereas Order 9 Rule 13 says that if plaintiff has already given evidence, the defendant has not given evidence, it is ex parte. Even if he submits his WS. That is what I have explained. क्या लिखा है? Does Order 9 Rule 5 applies to cases where summons was served as Order 5 Rule 9A? Summons are summons, yes. I think so. लिखा तो है he has failed using best evidence to discover the residence. So it can apply to Order 5 Rule 9. I can't see any reason why it will not apply to that. आप लोग के दिमाग में कहाँ से सवाल आ जाते हैं? आई कांट सी एनी रीजन व्हाई इट विल नॉट अप्लाई. Summons given to plaintiff for service. So if plaintiff has got the summons and he is not able to find, लिखा तो है, the plaintiff now, whereafter summons has been issued to the defendant or to one of the several and returned unserved. So even plaintiff can go to serve on him and he doesn't find him. So this will apply. Why not? Is service of summons by court not an order by court to appear in court? हाँ है ही. समन्स का तो सर्विस इसीलिए होता है कि कम. शुभम चौहान. CS in English now, I'll tell you that you read newspaper daily. You read newspaper daily, that is my advice, or listen to the news daily. You read newspaper daily, that is how you can do general studies, and keep reading on different things. You can allot 1 hour time to general studies every day. Nothing great. Or even English, 1 hour. That will be really perfect. And whenever class is conducted here of GK and English, you please must attend that. Because people take it lightly and then they suffer. Then they suffer either due to English or even due to general studies. So they are very important in that sense. You should not suffer. Order 8. Order 8 Rule 11 कौन सा है भाई? Order 8 Rule 11 कहाँ है? Order 8 Rule 11 कहाँ है? Order 8 Rule 11. Order 9 Rule 5 of defendant avoided summons. Then why suit will be dismissed? Dismissal of suit where plaintiff after summons returned unserved fails for 7 days. So now it will dismiss because plaintiff, it is not dismissed on this ground. You are mistaken, Aarti. This is not on this ground. It is on this ground that if it has not been served, then within 7 days he has to come to the court and he has to say to the court that it was not possible. So if you lag there, then dismissal. नहीं आरजेएस प्री के लिए आप देखो जाओ. अब प्री में क्या है ना, you have to go with cool mind, sleep well before examination, because see there are 4 options available to you there. So you just look into that 4 option and find the best option and do it. In many examination now you are required to mark with pen, so you cannot correct it later on. So be careful. If it is so, I don't know what is there in Rajasthan. If it is to be marked by pen, so do it now 5 questions at one time and mark it. Because if there is mismatch, it will be now huge problem for you. It will be huge problem. And look into these recent things and look into local laws and small acts because they are relevant, and most of the things you might have read also a little bit. Rajasthan questions are not so difficult, I think. So Aarti, you understood, I hope. पढ़ लो, कोई नहीं, इस समय कुछ है नहीं. आप सवाल जो कह रहे हो ना, इसमें कुछ है ही नहीं. तो बहुत बेसिक बातें लिखी है, तो आप एक बार पढ़ो. हाँ ठीक है. ऑर्डर 9 रूल 12 में क्या पूछ रहे हैं? When plaintiff dependent to appear in person does not appear, he shall be subject to all the provisions. Yes, ठीक है, वो नहीं आया तो जैसे आप नहीं पहले आते हैं तो whatever the consequence, here the same consequence. You did not come, plaintiff does not come, so dismissal of suit. So here also, if it does not come, dismissal of suit. Is this clear? Shubham Chauhan. Srishti Singla, are you clear? Srishti Gupta, Sresht Mahendru. Yes, this should be the mindset. Assis, Kasis Munjal, Bharti, Abhishek Tiwari, Aditi, Ayushi, all right, great. So I stop here, all right. I'll see you tomorrow with order 11 to, I think that I can go up to order 11 I can cover, 12 I can cover, 13 I can cover, 14 I can cover. I may cover till 15 or even 16 because they are just reading of bare provisions. There is no much dictation, so I can cover them. Christy, can we consider order 9 rule 9 exception to order 9 rule 4? A suit is only or partly dismissed under rule 8. Plaintiff shall be precluded from bringing. The rule 8 is procedure where defendant only appears. And what is rule 4? Under rule 3 or 4. Now they operate in different domain. You just see this. Not mathematical. They operate in different domain. Rule 4 says something else and rule 9, they operate in different domain. I don't think so. I don't think so. They operate in different domain. They're different region. When trial is said to be commenced, I have already dealt with. Somebody has written that Calcutta High Court or wo High Court or ye High Court. We'll talk about that. But I have already explained this point. I have already explained this point, my dear friend. Trial commences when evidence is taken. I have told you. I will be talking about trial. Don't be in hurry. अभी तो trial आपको पढ़ना है. अभी तो order 14 को पढ़ोगे ना, issues framing. अभी बताएंगे. First day of trial 50. When trial commences, we'll come to that point again. But I have already explained that point. Don't try to confuse yourself. That's very clear. Whatever I have taught that you believe right now, if there is any change, I will let you know. Don't worry. Is this clear? So I will come tomorrow with order 11 onwards. देखो सीआरपीसी सीपीसी समझने के लिए थोड़ा सा आपको शांति से रहना पड़ेगा. जैसे सीआरपीसी में भी framing of charge, it does not mean beginning of trial. It is when guilty plea is not accepted and then he says that I claim to be tried. So it is said that then trial begins. So it is not with the charge framing. But generally we say with the charge framing trial begins. So we'll understand that. Don't worry. आपने भी यहाँ लिखा after settlement of issues. To that extent you are right. But I'll let you know exactly because the question has been put to me and I'll be answering that question. Don't worry. Okay, bye-bye. See you.